at the heart of a justice system.
I call Julianne Genter.
Tēnā koe, Mr. Speaker. My colleague David Clinton has already spoken to this bill, and I would like to add my voice to his in emphasising that the Green Party will not be supporting the thrillingly titled Prisoners and Victims 2012 Expiry and Application Date Amendment Bill. Though the Select Committee has reported the bill back without amendments by majority decision, we do not feel that either the full context or full consequences of the bill have been appreciated. Now, extending two sunset clauses in the Principal Act may sound innocuous, and certainly other members speaking in the House have emphasized that it is very simple and straightforward. And we retain our concerns for two important reasons. First of all, it is not immediately clear that extending the sunset clause is a necessary step. Notwithstanding that, the Green Party only supported the Principal Act at its third reading on the basis that the legislation would expire. So, as part of a plan to reduce the amount of abuse in prisons, the Law Society in its submission made the valid point that case law precedent in Tanoa and Attorney General from 2007 casts doubt on whether Subpart 1 and Part 2 of the 2005 Act is now needed at all. So why the government is taking up precious time debating this bill is somewhat beyond me. But more importantly, we reject the assertion that because this merely extends the sunset clauses that the bill has no human rights implications, because it clearly does. The government's own Attorney General has released a Section 7 Bill of Rights report on the government's proposed Prisoners and Victims Claims Redirecting Prisoner Compensation Amendment Bill, condemning it as a denial of an effective remedy, which also includes a chastisement of the previous Attorney General for not making similar ruling in regards to the Principal Act. So how does extending the restriction to the right of an effective remedy before making that change permanent not contradict the Bill of Rights? Prolonging that denial is a denial in itself and should be considered as such in principled lawmaking. And in response to Mr. Goff's assertion that he's interested in putting victims at the heart of our criminal justice system, the Green Party absolutely agrees with this. And let's be honest that the Principal Act that this bill is extending never sought to put victims at the heart or to for victims to receive compensation and money. It was all about limiting the Crown's financial liability for the human rights abuses of prisoners. That is what it's about, and that's why it's limited to this. And clearly, because it had a sunset clause, that is why we supported it. Lawmaking should avoid perverse incentives, and in perpetuating the status quo, this bill fails in that regard. And that's why probably there's been so few cases taken and so little money awarded to victims as a result of it. Compounding the problem is the fact that where abuses happen, prisoners are less likely to make a claim, and that is exactly why there's been so few claims made or awarded. Making prisoners less likely to claim compensation reinforces the incentive to commit human rights abuses by lessening the chances of punishment against perpetrators. These are broadly the reasons why we will not be supporting this bill, why we do not commend it to the House. We realize that it will pass. We look forward to engaging in what will hopefully, but unlikely, be a more substantive debate to the government's future plans in regards to the Prisoner and Victims Claims Redirecting Prisoners' Compensation Amendment Bill. Thank you, Mr. Speaker.
Call Alfred Naro.
Mr. Speaker, I'm proud to take the final call on this.